Good morning, afternoon, or evening. Your video is about to start. I wanted to remind you of our newer Wednesday, 1 p.m. live stream Q&A on all things Social Security. Visitors are welcome to post a question in the chat, and I'll do my best to answer it. It's on a first come, first serve basis, so please get there on time. Otherwise, if you care to be a member and get some different kinds of perks, feel free to click the join button below or just click it to learn about them. Anyway, I hope to see you Wednesday. If not, enjoy the video. Bye now. Good morning. This was kind of an insightful question, so I wanted to respond to it in a video in case other people are wondering about it. The question was, how do they evaluate your RFC? When there's different dates involved, I think is the issue. If you have a remote alleged onset date of 8 years ago, so you're saying you were disabled 8 years ago, and you can prove disability began before the DLI, which obviously that's necessary. If you're going to get SSD, you have to prove that the disability began before the DLI. There are medical records that are from the military and the VA, and a couple civilian specialists as well. The person was 43 then and is now 50. So the question concerns, how do they figure out an RFC? Well, RFC is going to be at any time before the DLI. So whenever the DLI was, so let's say if the disability started 8 years ago and they stopped working altogether, it's very likely that the DLI is 3 years ago. So they're going to be looking at all the information from 8 years ago to 3 years ago. So 8 years ago would be 2017. 3 years ago would be 2022. The person was, in this case, 43 8 years ago, is now 50. But now 50 is after the DLI, if I'm reading this right. So the 50 isn't going to be helpful, not for SSD. If the person has an SSI claim and is under the financial threshold to be eligible to apply for SSA, that one might remain for the years after the DLI, but the SSD component will not because the person didn't buy any SSD insurance coverage for the last 3 years. The last they had coverage was 3 years ago and before. So in that case, the RFC is whatever the medical evidence showed at 43. What does it say the RFC was at 43? What did it say? And that's the beginning of the AOD. What did it say 5 years later? The end of the window of opportunity when the DLI strikes at what looks like 48. What was the RFC then? Did the RFC get worse? Did more, physical impairments that are limiting strike up? So the RFC at 43 might be different than the RFC at 48. But again, being under 50, and we talk about this a lot, you have to have a very, very limited RFC, more limited than if you were 50 or above to prevail. So it is a tough road for to prove that you met something between 43 and 48. It just is. Doesn't mean it's not done. We do it all the time, but it's very certain cases, and some cases it's not possible. We try to make sure we don't take those cases. We try to find the ones where, or we try to accept the ones in the limited compartments we have where the disorder, the kind of treatment that's available, are they already getting by the claimant, or the claimant is willing to go and follow up where necessary. We do take them. I every time one of mine scrolls out the door, I take another one. We always have kind of a waiting list, but that's what we do because we do take them. But it is rough. After 48, he's no longer insured for SSD, so that's not going to help him. and now he's 50 in 2025, if he has an SSI claim, that is something that he can still pursue. And the 50 rules will apply. Um, the RFC is going to be what the RFC is, and that RFC will determine at least one portion of the grid rule, and then the rest of it will depend on what his prior work was and all that business, and if he has transferable skills and whatnot. So yeah, the RFC is what the RFC is based on the evidence at any given time. An RFC at 43 might not be the same RFC they would decide at 48, but because the rules of whether you're disabled are the same at 43 and 48 for the most part, um, you know, the most stringent RFC in that time period where your residual functional capacity is at its worst, which is probably 48, but not necessarily, will be the one that they determine whether there's work that that person can do if they can't do their prior work. If the DLI was not 2 years ago, and let's say it was in the future in 2 years, then the person would be dealing with, they'll figure out the RFC at the different stages. They'll figure out what it is at 50 because there's going to be different rules that apply, right? Once he's 50, he's got a certain grid rule he might be able to try to meet. So the age does matter, but the RFC is going to be based on whatever evidence is going on at the time you're making the determination. In his case, it was all with the rules that apply to 43, 44, 45, 46, 47, 48. All right. So RFCs, it could be ever changing, of course, but, and the rules that apply, you have to look at those as well because they change based on age, right? But not so much when you're in your 40s. It's not till you hit 50 and then 55. And then there's this little tweak at 60, kind of. But anyhow, I hope that helps explain that, guys. RFC, your residual functional capacity, is going to be based on your medical records. So that's where that treatment is so important. And following up with specialists versus just saying hi to your PCP. If you have special problems, they probably deserve a specialist. All right. Okay, everybody. I'll see you later. And I hope to see you next Wednesday at the live Q&A that I'm sure I am planning on. All right. I'll talk to you later. Bye. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hey, so I love it when someone asks what an acronym is that I may have used. I may have said the entire word or just use the acronym. That's because these things are just everyday language in my world, but I definitely understand that sometimes they're not going to be in yours, particularly if you haven't been doing this long, have not been a claimant for long. Okay, so big shout out. Thank you to Royce. Royce, thank you for asking what an RFC is. Okay, so the way I put it simply is RFC, which stands for residual functional capacity, is it's an assessment done by the SSA to determine what your residual functional capacity is after consideration of all the limitations from medically determinable impairments that they find in your evidence, whether it's your medical evidence combined with your function report, that kind of thing, or other evidence. So I'm going to post a link to the SSA page where they define it and describe it. And let's just go into that for a minute here. The definition under the SSA page, okay, is the RFC assessment. It describes what an individual is able to do despite functional limitations resulting from medically determinable impairment or impairments and impairment-related symptoms, and it is an administrative determination of an individual's, excuse me, capacity to perform work-related physical and mental activities. They also include in that definition the notation that it's based primarily on medical evidence, but may also include observation or description of limitations, lay evidence, including your own statement, meaning you, the claimant. So that's when we say there's medical evidence, and then there's this other non-medical evidence. They can consider that. Now, granted, we all know that medical evidence is going to be the foundation of any RFC finding. So the other may be gravy or frosting, depending on how you look at it, but it's going to be things that you want to be seen in your medical evidence. Diagnostics are very, very huge. In the event you have an articulating medical professional, as opposed to a robot who actually articulates what they know are some functional limitations of the kind that are relevant to day-to-day activities, which are often corresponding to activities you would have to be able to do or tasks you would have to be able to do in the workplace. So let's go down a little bit further. I always point out the RFC is going to be one of the steps in the sequential evaluation process. It will happen at step 3 after they've decided whether your diagnoses and medical records constitute a listing level impairment. Okay, so if it was a listing level impairment at the earlier part of step 3, they don't have to go on to assessing you in RFC and making that determination of what you can do because you would have prevailed at the beginning of step 3. Okay, so they go on to say more specifically, an RFC is required in all disability determinations where a medical decision is necessary, and the individual has a severe impairment or multiple non-severe impairments, which in combination are severe. So those are just 2 other additional points I'll just mention briefly here. You can't get to an RFC until you have proven that you have a severe impairment. We prove our impairments, then we have to prove they are severe. Then they get to, once it's severe, and it could be one of them, multitude of them, or in combination, sometimes something that's not severe, but in combination with that other thing you can't do, or that other impairment you have, the situation is now severe combination of impairments. Yeah, so they go on to say the impairment already does not meet or equal the listing of impairments. I described this before. If you're at the beginning of step 3, that they're performing step 3 on your case, you actually don't have any idea when that is. And you don't meet that listing at the early part of step 3, that's where they go on to the later part of step 3, which is assessing your residual functional capacity. And they go on to say, a determination of ability to perform substantial gainful activity is required. I'm trying to get it after the parentheses here. Or an otherwise not severe impairment precludes past relevant work because of the unique features of that work. So that's an interesting little point out they make. If you have a non-severe impairment that would allow for jobs in and of itself, but it precludes your past relevant work, and your past relevant work will implicate, say, the grids for those 50 and older. That is a situation where they would do the RFC. And they add on that at each adjudicative level, this will occur. So it occurs on initial, it occurs on reconsideration, it occurs at the ALJ level. So once you have your hearing, the ALJ is going to be determining your RFC there also before he or she makes a decision. They note that since a claimant is entitled to a new determination at each decision-making level, a new RFC assessment must be made independent of prior RFC assessments. This is really important. This is how we often overturn an initial denial on recon or a recon denial at ALJ. They can't just take the RFC that was decided initially, right? The first few months of your claim and then embrace it in the next one. Do they know what that RFC was? I'm pretty sure they do, but they have to make an independent examination. And that's even true if you do not have new medical evidence. However, it is going to be so important that you have continued to treat. If you didn't have current diagnostics, go get them. If you were, if physical therapy might be something that should be considered, maybe you start, because these things are all going to provide additional medical evidence that can be considered for a different RFC. It's where if you didn't realize on initial because you hadn't learned much about the process, and now you know that, gee, if I had just had medical workup for my arthritis in my fingers to prove that I couldn't do that secretarial job they said I could do, because I can't type that much anymore, this may have changed. So then you go get that evidence, make it follow up. Don't just do a one-hit wonder. Be serious about it. And that evidence will then there be on recon. And that new RFC will have to have some notation of the limitations with the fingers. So all this can assist in getting you closer to a 1. It might take you all the way to ALJ. It often does. But that's what it's all about, guys. The RFC, it is the single most important probably aspect of your case. Okay, so RFC is super important. I will talk to you later. I hope that helped, Royce. Bye-bye now.